Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am William Meade. With me today are Justices Sachs and Hodgens. If you've been here before, you know that our rules are each side gets a combined 15 minutes. We do not entertain any rebuttal. We have read everything, so my best advice is to get right to the point. With that, I'll call Ms. Spanos. I'm sorry, this case is partially impounded, and it's 23P 1246, Department of Children and Families versus Mother and Another.
Good morning, Your Honor. May it please the court, I am Attorney Diana Spanos, and I'm representing the appellant mother in this case. The appellant, this is a competing plan case, and the appellant mother's argument is that the trial judge failed as a matter of law to compare the two competing plans, placement with her parents.
Are there any statutes or cases that bear on what a suggestion or idea needs to be and how formal it has to be to rise to the level of a plan that has to be given the even-handed consideration? Because it appears to me that this was a suggestion at trial based on the testimony of the maternal grandfather and closing argument of counsel. Is that enough to be a plan? Does it have to get in the works earlier and give DCF a chance to sort of vet it and consider it?
To answer your question as best as possible, no, I'm not aware of a statute or regulation, but I do believe that it's inherent upon the court. I mean, the grandparents had applied for a home study back in 2018, which was denied. But their interest in the children never stopped. They continued to visit with the kids, presented themselves throughout.
Right, but did the mother or mother's counsel at any point after the fair hearing decision that wasn't targeted by judicial review, at any point after that, did anyone call to DCF's attention, hey, the maternal grandparents are still interested, you should keep them in the mix? Obviously the mother hopes that her rights won't be terminated, but if they are, or if she's found unfit, did anyone?
Not prior to court that I'm specifically aware of, but I think from the mother's perspective, her parents were always there and willing and able and desired to take custody of the kids.
Your argument is that the judge didn't make findings about it. So how formally does it have to be, does the proposal have to be made in order to trigger that obligation for findings? I mean, surely if the mother testified, oh, well, my parents could take the children if I can't, that alone wouldn't seem to be enough to require the judge to make the detailed findings. So where is the line?
Your Honor, I respectfully disagree. I think at hearing, that was an opportunity that the mother had to present her parents as the alternative placement. Again, I don't believe there is a statute, but I think that the case law just simply supports it. I think the way you're looking at it almost seems like a reasonable argument, a reasonable efforts argument that they didn't, if it's not raised, it's waived. I don't think that should be the case. Again, mother's position is that she wished, if she were to be found unfit, that the children be placed with her parents.
DCF also says that the maternal grandparents weren't proposed as an adoptive resource, but more as a potential custody option while the mother sought a redetermination in 6 months, maybe another home study, another interstate compact study. What's your response to that?
I'm sorry, I kind of just lost your question there.
That the maternal grandparents weren't proposed as a resource for adoption.
I don't believe that they have to be. I mean, frequently there can be a situation where the court could have ordered a guardianship, sua sponte. They could have done multiple things. The thing is the court just simply never considered the grandparents. The court only made 4 findings, specifically, all of which were based on very stale evidence. If you think back on it, the findings that the court makes, specifically finding number 92, effective, and I will also raise the issue that a finding of fact is supposed to be a factual deduction from the evidence essential to the judgment in the case and not merely a recitation of the evidence, which all 4 of those findings specifically were. So finding of fact 92, the court is relying on 51A reports from 2016, essentially my math is not good, but 7 years before the trial. And a lot can happen in those 7 years. The other finding of fact 93 involves the 2 home visits that the department did at the grandparents' house. And they were really focused much on the uncle, the mother's brother, who had had an issue in 2010. So by the time that gets to court in March of 23, I mean, that's, again, 13 years after. So it's all stale. And when the grandfather testified, I thought he was actually very concise. He testified about how after the death of the second baby, the police were helping them put the baby in the car, and they were ready to take that child home until DCF showed up and assumed custody. And in DCF's defense, at that point, there were reasons to be concerned, but the ultimate finding after the child was evaluated at the hospital is that it was a SIDS death. It was not impacted by drugs or anything. It was a SIDS death, a tragedy.
If we agree with you that it was error not to make findings, what is the remedy, or what is the scope of the remedy?
I think it would have to be remanded for further evidence taken on.
But on what issue or issues? Is it just
on the competing plan case? And I raise the issue because
is the termination decision revisited?
I think that the termination decision probably has to be, because mother should be entitled to offer her perspective regarding that. And if her rights have been terminated, there is reason to suggest she does not have the right.
Well, we could still, as in the Dora case, we could indicate that there was sufficient evidence for termination and still remand it on the issue of whether or not the judge properly considered or fully considered the possibility of the adoption by the grandparents.
I think that could be appropriate. I just raise it as I wouldn't want it to go back to the trial court and then have the judge say, mother can't participate, because I do think her perspective is valid. And I mean, you had the option, these were maternal relatives who clearly loved these 2 children. And
well, can she participate without the termination decision being vacated?
Can she participate with?
You just suggested you'd
well,
hate to have it go back.
If this court fashioned an order that would allow her to participate, I think that would clarify it. I think it leaves, I think it's open-ended. Whether or not, I think there is case law that would suggest she can't.
Okay,
and I
you.
believe I am now over my time,
Thank you.
but I will rely on my brief. Thank you.
Mr. Rosenthal.
Good morning, Your Honors. May it please the Court. Steve Rosenthal, representing the appellant father. First off, I'd like to thank the Court for accommodating me when I was sick a couple of weeks ago and continuing this matter. I don't think there's a person in this room who doesn't know somebody who has dealt with an addiction of some kind or other. And we all know that there can be relapses. In father's case, with the exception of a 2-month relapse, there's a documented 4-year, in excess of 4-year, period of sobriety.
But what about since April of 2021?
He did not document his sobriety with DCF during that period of time.
And he was arrested for possession of a Class E substance. I'm not talking about anything that was in the newspaper article, but it's pretty clear he was at least arrested for possession.
He was arrested, but those charges were ultimately dismissed.
Right, but that doesn't suggest that there's reason for concern.
Well, Your Honor,
that he's using, and then he drops out of the VA treatment and doesn't participate in services with DCF after that point. So at least there's substantial cause for concern that he's that this wasn't just a temporary relapse, or this was another relapse.
I'd like to point out that certainly there was no evidence that he was under the influence at the time of the arrest. There were court hearings, and apparently the matter was dismissed as lacking probable cause.
Dismissed for failure to prosecute, wasn't it?
There was a probable cause hearing that was canceled at the Commonwealth's request, if I remember correctly. But in addition to all that, although Father's visitation was somewhat sporadic for a period of time, in the months preceding trial, he was visiting on a regular basis, and you know that DCF would be observing him to see if there were any signs of his being under the influence. And there's nothing in the record for all the visits that took place between April 2021 and the trial to indicate that he ever appeared under the influence. There were no police responses. There were no other drug-related arrests. So I would suggest that the evidence that Father maintained his sobriety was fairly strong, and the idea that there were concerns because he wasn't participating, I concede that amount, but the fact remains that it was DCF's obligation to prove in court that he was not maintaining his sobriety during that period from 2021 until the time of trial. Now, there are a couple of issues that relate not only to Father's case, but are sort of broader issues. One of which is the issue that I raised in this particular brief about DCF not fulfilling its responsibilities under its own disability policy. Now,
let me just ask you about something, because
Yes.
it wasn't really clear to me with regard to this. There were a number of psychological issues in play here, in addition to the substance use issues. The evidence was he was in the Marine Corps for a couple of years. Was this combat related? Because I didn't see a reference to that.
This occurred while he was in the States.
I see.
I don't know the exact circumstances, but he suffered a major shin injury, which is how it was described in the record. And unfortunately, as many people do in today's society, you're treated with painkillers, and once the painkillers run out, an addiction problem develops. But in this particular case, DCF knew about Father's psychiatric issues from day one. It's in the investigator's report. It's something that percolated throughout the proceedings. And my argument here, and this is something that I've seen come up again and again, is that DCF has a certain responsibility under its own disability policy, which, by the way, was the result of a Department of Justice investigation. And they have to do at least one of three things. They have to offer special accommodations to the person with the disability. They have to seek guidance from their supervisors, and there is a whole slew of experts in the field who are employed by DCF that DCF can consult for how to deal with this particular person's psychiatric issues. There's no evidence that any of that was done. And
why couldn't that have been raised at trial? Failure to comply with the disability policy.
Well,
I mean, I understand where the case is in before trial and attorneys aren't actively involved.
The issue could have been preserved more fully.
Well, it wasn't preserved at all, really, was it?
Okay,
I know
so
you're
it wasn't preserved. However, under adoption of Chad and some other cases, including May, M-A-E, and Otto, there were situations where where the lack of reasonable efforts was not specifically raised during or up to trial, and because the issue was something that was a thread that ran throughout the litigation.
What does that mean, really, in the footnote in Chad? What kind of rule does that create that we can administer in future cases? If something was an issue a theme that ran through the life of the case, then it doesn't have to be raised at trial?
I'm not saying it doesn't have to. I'm saying the appeals court, in its discretion, can recognize that this was an issue and that it should have been addressed. I can't speak to what trial counsel did or didn't do in this case, but I can say that, again, DCF knew about the issue from day one. I would also like to point out that it seems unfair to me that, as is usually the case, and it was in the case in this adoption of Joan case just from a week ago, the mother's argument that the department failed to comply with its own disability policy is not persuasive, where the mother does not identify any other services that the department should have provided to address her mental health and its effect on her parenting. Well, they're asking an irrational person to come up with a rational plan to solve her irrational problems. They didn't consult, in this case, they didn't consult father's attorney to say maybe we should have an ADA meeting to discuss this and try to work something out. They didn't do that. I only have a few seconds, but I would like to speak very briefly regarding the issue about the criminal history. And I'd refer you to a case that came out fairly recently called Adoption of Lincoln, 23P 862. In that case, the court at least began to draw a distinction between arrests and convictions. And father's so-called criminal history was not a string of convictions. There were arrests spread out over a long period of time, but father the last conviction he had was 6 years before trial.
We're going to have to leave it there, Mr. Rosenthal. Thank you.
Right. If there are no other questions, Your Honor, I rest on my briefs. Thank you for your time.
Ms. Murphy.
Good morning. May it please the court, Lynn Murphy, excuse me, for the Department of Children and Families. This is a termination of parental rights case that involves two parents who struggled with a lengthy and significant mental health and substance abuse issues.
So let's talk about mental health history. I don't see a finding that the mother has a mental health problem or
there is
any discussion of what the nexus might exist between that unidentified problem and her fitness. I mean, there are references to concerns being raised, but there's never a diagnosis. There's never even an identification of the symptoms that gave rise to the expression of concern by the main social worker or anybody else I can see. This issue seems to have acquired a life of its own without any evidence to support it.
I would disagree. I think the court did a good job and was very specific in its conclusions. And the court does specifically find a connection between mother's mental health issues and her parenting.
Right, but which way does that causal arrow run?
It runs towards, it was a factor that impeded her ability to address her parental deficits, right? We had this is not uncommon. You have a substance abuse issue and mental health. Those two factors
Sure, they can work together, but you have to,
right.
Don't you have to be able to point to what the specific mental health issue is? I'm not suggesting that there necessarily has to be a diagnosis if the mother is exhibiting symptoms yet is refusing to be evaluated, but what are the symptoms? What are the signs that she has mental health problems?
Well, there were no number of reports, documents in the record, and most importantly, the main social worker mentioning the mother was not participating in mental health treatment,
okay,
which was why she was denied.
Why does failure to participate show anything if there's no indication that there's an issue that needs to be addressed?
there was an indication that there was an issue to be addressed. And again,
What
the
made the
interconnection-
social worker in Maine say mother needs to get a mental health evaluation or she needs to deal with her mental health issues? What caused the social worker to say that?
Well, her refusal to consistently participate in mental health services.
Okay,
This has gone on.
are you saying that the substance abuse disorder in and of itself is the mental health issue that has to be dealt with?
No, I'm saying they're interconnected. It's very common for those two issues to be interconnected. They're separate and distinct, but also impact each other. And that is often the case, and that's what the trial court found here, that mother's mental health and substance abuse were connected to make or result in her inability to parent her children. And the fact that the department had no information on her diagnosis was due to mother's behavior itself. She would not sign releases. When she did sign releases, she would revoke them.
But is a failure to sign a release the sign of a mental health problem?
No, but that keeps the department from being able to identify this specific issue.
Doesn't the department need a reason to think there is no there, that there is a there, before it holds against the mother her refusal to waive her privacy rights on the issue of mental health?
I think there was an abundance of evidence when you look at all the 51B reports, when you look at the assessments, when you look at the service plans, when you hear the testimony of the social worker and the supervisor. This was not something that the department made up. This was many years. We're talking 6 years of services, and there was much evidence to show that this was a dysfunctional family and that mental health was a problem. Both parents participated in mental health treatment, and when they participated, not so much mother, but more so father, you did see a correction. In fact, father had a dual diagnosis program where he did substance abuse and mental health through the VA, and he did quite well with that until he decided not to participate any longer. And the problem with mother was she was even more evasive than father. So yes, we never had a diagnosis, but there was abundance of evidence that this was an individual who had significant issues, including mental health.
So if, just assuming hypothetically, we were to conclude that the judge's reliance on mother's mental health was not supported by the evidence, how can we be sure that that didn't affect the termination decision? In other words, is there enough other than the mental health issue to justify termination? And do we know the judge would have terminated?
Absolutely. In this case, we not only had an arrest for fentanyl 6 to 7 months before the trial, but mother tested positive twice during trial for fentanyl and other substances. She did not get a housing until 3 months prior to trial, and by the time of trial, she was behind in the rent. She clearly, in this case, the department bent over backwards to work with mother. We had 2 ICPC requests for mother, once before she obtained her apartment and after. And both times, she was rejected by the state of Maine, and again, the social worker specifically finding, again, substance abuse and mental health issues that disqualified her from placement. Well, I think the court did a good job in its findings in explaining exactly why termination was appropriate here. And if there are no further questions, I will.
The judge's failure to make findings about the maternal grandparents, how do we deal with that?
I think those findings were made based on the evidence at trial, and the court concluded.
Well, the only discussion of the maternal grandparents seemed to be from the judge's discussion seemed to be from 2019, and this was early 2023. The maternal grandfather testified. Counsel made quite an issue of it, the availability of the maternal grandparents in the closing argument. The judge didn't deal with any of that. I mean, perhaps the judge had reasons why he didn't think that was a good placement for the children, but how do we know?
Well, I think the reasons were specific in that, first of all, this wasn't an adoption plan. This was a placement plan. And again, the department reviewed the maternal, or investigated and considered the maternal grandparents on 2 separate occasions.
Right, but 4 years.
And they were denied.
But 4 years earlier.
Right, and nothing had changed because we still had.
How do we know nothing had changed?
Because of grandfather's testimony. He was still reluctant to admit that mother had serious issues. There was nothing to convince the court that anything had changed.
Well, if the judge had said, I've listened to the grandfather's testimony, I don't credit his assertions that things have changed, I don't think it would be in the best interest of the children for this placement with the grandparents to go forward, then we would know what the judge thought. But it seems like the judge just didn't address it at all.
I would disagree. I think the judge could have made additional findings, but it was not necessary, particularly where the plan was not an adoption plan. That was a placement plan.
Okay, so I think Hugo says a judge should provide an even-handed assessment of all the facts surrounding both the department's plan and any competing custody or adoption plan.
Right.
So even if this wasn't an adoption plan,
right.
Why didn't Hugo obligate the judge to make findings?
Because the judge found that the department's plan was superior because it provided permanency for 2 children who had been in state care for a majority of their lives. The permanency plan.
Superior to what?
To continued lack of permanency through just a placement plan. The judge was very clear that the children had spent a majority of their lives already in foster care. It was time for them to be.
So is the problem that no one used the magic word adoption, that neither the grandfather in his testimony nor counsel?
I think that was a very significant factor that the judge was allowed to rely on.
Well, the grandfather did expressly say, I'm willing to adopt. He actually used the word adopt in his testimony.
Yes, but he did not say that until he was cross-examined on that piece. And at the closing argument, you can see that the attorney for mother presented him again as a placement option. And he also testified that he would be willing to take the child until such time as mother. He hoped that mother would get it together, for lack of a better word, and he still had hopes that mom would rehabilitate herself. And on this record, there was very little, if any, excuse me, there was very little reason to, I can see my time is up.
I have to leave it there.
The rest of my brief, thank you.
Ms. O'Brien.
Good morning, Your Honors. Tamika O'Brien on behalf of the children. Your Honors, this case comes down to the simple fact that love is not enough. Mother and father clearly loved their children. The one thing that they did throughout this case was visit mostly consistently. There was a period of time in 2022 between March and August that they didn't. But that's all that they did here. They did not prepare themselves to resume custody and be reunited with their children. And unfortunately, that is really important. DCF could not reunify these children without stable housing. Mother had obtained housing, although she was behind on her rent a couple months before trial. We don't know what father had. He did not. He came to trial one day, excuse me, but did not testify. We have no evidence on what he did or did not do. And while it's DCF's burden to prove parental fitness, when a mother leaves the state and goes to Maine and does not provide any information as to what she's doing, and when a father does not return any of the social worker's phone calls for a year, during visits says, yes, I'll do X, Y, and Z, I'll do this, but then there's never any follow-through. These children need consistency and stability. And in this case, the trial judge determined that that consistency and stability was best had and in the children's best interest with the foster parents that they were placed with. The children, importantly, were placed together at the very end. And I think that after 6 years, the trial court rightly assumed that these parents were not going to be able to pull it together enough to care for these children in a manner that was in their best interest. I'd like to just briefly speak to the grandparents. I know they testified at trial that they would be willing to adopt, but it had been a considerable amount of time between the first time that they had said that and then trial date. At no point did they come to DCF or the mother come to DCF and say, I really want you guys, DCF, to focus on my parents, and let's see if this can work. This is something that was really proposed at trial. Perhaps the trial judge could have said, DCF, I'd like you to look into this a little bit more, but that didn't happen here.
Isn't that a lot to put on grandparents? I'm just trying to put myself in the position of this grandfather who's testifying, and he's kind of being grilled about, why didn't you do this? Why didn't you do that?
Sure.
And his response is that understandable, that, we hoped that our daughter would get her children back, and we were kind of standing by to see how things would unfold, and that seems like kind of a rational response. I mean, if you're not schooled in how DCF works or how the law works, and that your every word is going to be examined potentially years later by a judge, it seems like a lot to put on him, doesn't it?
Sure, I agree, it is a lot, but it's also very telling that, they'd hoped that mother would get in a better position. I mean, I think that it goes a long way to showing how much in denial the parents were as to their own child's issues. And, love isn't enough, but neither is hope. And if they're visiting on a regular basis, you can look at the DCF social worker and say, what do I need to do to be considered as an adoption plan? And mother had an attorney, and father had an attorney, and nobody raised this before. And this is, yes, maybe we don't put that on the grandparents, but mother and father had counsel, and they knew well in advance whether or not the maternal grandparents were
So at what point does that have to be raised before or at trial in order to trigger the judge's obligation to make findings? Why isn't it enough that the grandfather testified as he did and that it was argued in closing?
I don't have an answer for you, Your Honor, and I'm not going to pretend to, but I do think that, the day of trial is not enough. There was a period of time where they were originally considered, and then DCF said, we're not going to consider the grandparents anymore because they don't really have a full understanding or acceptance of mother's issues. And between that time and trial, nobody raised this again. So I think it's a lot to put on DCF to say, well, you guys should have considered us, but you didn't, and we didn't tell you, but, that's really, neither here nor there. So, Your Honors, the children maintained that it was in their best interest that the parents' rights be terminated, and that the adoption plan that the judge found was in their best interest was proper. And for that reason, we ask that the court affirm the lower court's decision. If there are no other questions, then I rely on my brief.
Thank you. Thank you all. We'll take it under advisement. With that, I'll conclude our session. I'd like to thank my colleagues, the court officers, our law clerks, the clerk's office, and our excellent timekeeper. With that, we'll stand in recess.
All rise, please.